At first, there was the Constitution of the United States. Then came constitutional law, the body of authoritative, mainly judicial interpretation of the document, and later still, common opinions, including some widespread misconceptions, even among the educated, about both the Constitution and constitutional law. I shall attempt over the next 20 minutes or so, no, let's make it 30, to explore four such misunderstandings. Misconception number one: the Constitution guarantees life, liberty, and the pursuit of happiness. When I just said at first there was the Constitution, I lied. 11 years before the Constitution was written, there was the Declaration of Independence. The phrase, life, liberty, and the pursuit of happiness, is from the Declaration, where it is presented as a partial list of the rights with which human beings are endowed by nature or by their Creator, also called nature's God. It is in order to secure these natural rights, the Declaration teaches, that legitimate governments are instituted, and that just powers must be delegated and channeled into forms which seem likely to bring about the people's safety and happiness. In other words, in the absence of government, natural rights are insecure. Government, armed with just powers, is needed to make these rights secure. But if government is indeed to promote safety and happiness and not their opposites, it must be carefully crafted. Here the Constitution comes in. It is instrumental, a means to at least those ends proclaimed in the Declaration of Independence. But it is a distinct document. As an instrument, it is a more practical document, which may explain why it does not repeat the seemingly, but not really, open-ended phrase, pursuit of happiness. The nearest the Constitution comes to such a repetition is in the guarantee of the Fifth, and later also the 14th Amendment, that no person shall be deprived of life, liberty, or property without due process of law. Perhaps unlike other examples of the pursuit of happiness, property is something definite and tangible, around which claims can be staked, regulations composed, and disputes adjudicated, making use of manageable standards. Thank you. I could try singing it too. We must not here imagine property as passive possessions. To the founding generation, property was a dynamic concept. It is the concrete result of a rational application of one's productive capacity, a logical and practical extension of one's very self. Whatever else the pursuit of happiness may include, the ability to acquire, hold, and dispose of personal property is an indispensable ingredient. Also essential to our understanding is that one may be deprived of life, liberty, and property if such deprivation is accomplished with due process of law. The securing of natural rights requires their orderly exercise within a system of civilized rules and procedures, including rules that may, under appropriate circumstances, diminish or even eliminate particular life, liberty, or property for the sake of the general good. The most obvious example is the necessary power of government to punish convicted criminals. Further, we should be wary of the reductionism that would condense the Constitution's goals or purposes to a single principle. Its preamble sets forth a short list of a half dozen ends, which, though mutually entwined, are conceptually distinct. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. Much of constitutional law consists of working through the tensions that must inevitably arise among these several purposes. For example, that between liberty on the one hand and the common defense, or the general welfare, on the other. We must, that is, be mindful of this subject's complexity. American constitutionalism is not the realm of simple answers. Misconception number 2, the locus and the scope of Congress's delegated powers. A misconception, which seems especially characteristic of the libertarian right, is that Congress's legislative powers are limited to those mentioned in Article 1, Section 8 of the Constitution. Now, Article 1, Section 8 is indeed a list of subject areas about which Congress is authorized to make laws, but it is not a comprehensive or exhaustive list, as its final clause makes clear. Under this provision, Congress may make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. This clause signals that there are powers vested in the U.S. government in addition to those enumerated in the immediately preceding clauses. A scan of the remainder of the Constitution reveals a small mountain of such other powers, some quite important. The power to direct the manner of conducting the decennial census, the power to impeach and try civil officers of the United States, the power to alter the regulations the states may make regarding the times, places, and manner of electing members of Congress, and to designate the date of Congress's annual assembly, the power to set the amount of the members' compensation, and to create civil offices under the authority of the United States, the power to prohibit the migration or importation of slaves beginning in the year 1808, the power to determine the time for choosing presidential electors, and the uniform date on which the electors shall cast their votes for president, and to declare what officer shall act as president in the event of the removal, death, resignation, or disability of both the president and the vice president. The power to establish federal courts inferior to the U.S. Supreme Court, the power to make exceptions to and regulations of the Supreme Court's appellate jurisdiction, the power to declare within certain prescribed limits the punishment for treason, the power to prescribe the manner in which the public acts, records, and judicial proceedings of the states shall be proved, the power to admit new states into the Union, the power to propose constitutional amendments, and the power to enforce the abolition of slavery and the rights of due process of law and equal protection of the laws, and the right to vote without regard to race, sex, failure to pay a poll tax, or age for U.S. citizens who are at least 18 years old. Closely allied to the Article 1, Section 8 argument is a notion that has gained traction among a branch of the conservative movement, the so-called Tenthers, that the 10th Amendment limits federal powers to those expressly named in the Constitution. That amendment reads, "The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people." Clearly, this text affirms that there are some powers not delegated to the government of the United States. Just as clearly, it does not state what the relevant limitations are. In particular, as the Supreme Court noted in 1819 in the landmark case of McCulloch versus Maryland, it does not follow the example of the Articles of Confederation, the first written Constitution of the United States, of modifying the verb delegated with the adverb expressly. That is, it does not read, "The powers not expressly delegated to the United States by the Constitution, nor prohibited," etc. The 10th Amendment is thus open to the recognition that the government of the United States is clothed with implied as well as expressed powers. and it leaves the discovery of the extent and the limits of those powers to a fair construction of the entire document. Properly read, the 10th Amendment is not about limiting the powers of the national government at all, but about reassuring the state governments that they too have significant powers, subject to the political control of their respective people. Misconception number 3, the anti-democratic electoral college. Every 4 years, when we hold a presidential election, we inevitably hear calls to abolish the electoral college method of choosing the president and vice president, and to replace it with a system of direct national popular election. Invariably, among the criticisms, is that the electoral college reflects hostility toward democracy among the men who composed the Constitution in 1787. Now, the founders were, to be clear, skeptical about democracy, and rightly so. Both ancient history and contemporary practice revealed cautionary examples of the incompetence, instability, and injustice to which popular government seemed especially susceptible. But they also appreciated that the American people's basic political character or inclination favored popular government. For this reason, the Virginia Plan and the Constitution that grew out of it lodged the legislative power in a Congress, one part of which was to be elected directly and fairly frequently by the people. The executive power, however, posed different considerations. While there might be no special harm in the president being a popular figure, this was not the only or even the principal quality that they saw in his method of selection. More important than popularity was that the president be substantially independent of Congress, over which he was supposed to function as a check, that he be a character of national stature rather than a local favorite of narrow vision, and that the process of his selection be guarded from corruption and especially from foreign influence. How to devise a method that accomplished all of these objects was not a matter of pro or anti-democratic ideology, but a practical problem which called for a practical and what turned out, not surprisingly, to be a complex solution. Crucial to understanding their solution is appreciation of two historical data. That the United States in 1787 lacked an organized national party system, much less a two-party system, and the assumption of the principle of deference. The anticipated consequence of the former fact, the absence of political parties, was that unless a national hero like George Washington happened to be available for the presidency, there would be no nationally known official candidates. The people's impulse would be to vote for their local favorite, their state's governor or senator, or their town's mayor or most prominent private citizen. The vote would fragment in 13 or more directions, and the person elected might be merely the champion of the largest faction, who enjoyed the support of only a small portion of the total political population, an outcome which could only in a tenuous sense be called democratic. The consequence of the second assumption, deference, was that the people would repose confidence in their state leaders to know who the characters of national stature were and to cast their special votes as presidential electors accordingly. The mechanism spelled out in Article 2, Section 1 of the Constitution is more intricate than I just described. Its complexity notwithstanding, Alexander Hamilton observes in Federalist Paper number 68 that although other parts of the then proposed Constitution had come in for much criticism, this provision had not. And he describes it as, if not perfect, then at least excellent. I ask my students, how would you like to have a comment like that on your term paper? Not perfect, at least excellent. Here, history took matters in a different direction. Within 10 years of the Constitution's adoption, the country had the beginning of a two-party system. Presidential elections became contests between candidates who were already generally known, because the parties had nominated them. And the office of elector was transformed from a deliberative decision-making office to a ratifying one. Presidential electors were no longer chosen to exercise their own judgment about who should be president, but to register the judgment that the people in their respective states had made by choosing electors of either the Federalist or the Jeffersonian Republican Party. The process, which was never essentially anti-democratic, had become more actually democratic by virtue of an extra-constitutional historical development. And misconception number 4, First Amendment freedom of expression. It is a frequent practice among constitutional commentators, including several Supreme Court justices, to refer to the First Amendment's protection of freedom of expression. They really shouldn't. What the amendment prohibits, in part, is abridgment by Congress of the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. Common sense, based on everyday experience, should remind us that not all expression deserves to be called speech. Just listen to popular music on the radio. I'll step on everybody's toes sooner or later. Speech, properly understood, I would suggest, is logos, reasoned argument. And the sequel language of the amendment informs us that the kind of argument envisioned here is primarily political, concerning those matters about which government can be petitioned to make public policy. Claims to First Amendment protection that such matters as commercial advertising, artistic expression, or merely personal exposés might make are secondary and derivative. They are the perhaps necessary buffer zone of other things that can be said, which must be preserved in order the better to protect the core value of political deliberation. On the other hand, however, there is some obvious sense to the view that persuasive speech about public matters need not always be verbal. That, for example, the display of a flag or a bumper sticker, the activity of picketing, the performance of a politically charged vignette, or the refusal to recite formulas that do not reflect one's convictions, are also forms of implicit or symbolic argumentation, and are therefore constitutionally protected. We can readily appreciate what Justice William O. Douglas, quoting Professor Edmund Kahn, called the firstness of the First Amendment. Free political discussion is the indispensable matrix within which a self-governing people makes decisions about all other matters of public policy, including the extent and the limits of all other rights that are subject to legal regulation. The freedom of speech that the First Amendment protects is therefore arguably entitled to a preferred position within the constellation of constitutional rights. To appreciate how far constitutional law and popular understanding have strayed from these distinctions, I cite two Supreme Court decisions handed down in 2010. One much commented on, the other hardly noticed at all. In Citizens United versus Federal Election Commission, the court struck down provisions of the Bipartisan Campaign Reform Act of 2002, which, as applied, would have prohibited a political advocacy group from running a campaign advertisement within 60 days of an election. In other words, the court upheld the right of a political group to speak about politics and overruled an act of Congress which attempted to abridge that right because the advocacy group was a corporation, that is, an association of like-minded people. A more faithful application of the First Amendment's core purpose than this ruling would, in my judgment, be hard to imagine. Yet the case was decided by the narrowest margin, 5-4, and generated a welter of controversy because it was said corporations have too much power. Freedom of speech, by this reasoning, waxes or wanes depending on the nature or identity of the speaker. Just substitute for corporations some other collectivity, like socialists or teachers or Catholics, and one can appreciate why the very heated opposition to this decision by many supposed liberals is paradoxical. The other decision, United States versus Stevens, struck down a federal law banning depictions of animal cruelty, so-called crush videos. The vote was 8-1, with only Justice Samuel Alito dissenting. Notwithstanding my comment about maintaining a buffer zone around political speech, I confess some sympathy for Justice Alito's position. I am hard put to discern any redeeming political, social, scientific, or even artistic value in such displays of private depravity. We may see here, too, the meaning of my earlier parenthesis, that the pursuit of happiness is not as open-ended a concept as it may at first appear to be. Does the peculiar pleasure that certain deranged souls derive from acts of gratuitous cruelty and sadism really deserve to be called happiness? One could say much more on this topic, but time and decorum constrain us. Suffice it to observe that examples abound which provide food for thought about the disjunction to which I alluded at the beginning of my remarks between the Constitution, constitutional law, and mischievous opinions about them. I thank you for your kind and patient attention.